Hey, good morning. It's Bernard Nomberg with another weekly episode of NOMBERG Law Live. Thank you for joining with us for a few minutes. Got my buddy, attorney from Tuscaloosa, Clint Mountain. Good morning, Clint.
Good morning. Thank you for having me.
And I appreciate you spending a few minutes with us today. We've got some good topics that we're going to talk about. And one area that we're going to talk about today is dealing with municipal liability and what that is. Clint will describe in just a second. We're also going to talk about sovereign immunity, which in layperson's terms is the king can do no wrong, but we'll get into that in just a second. Hey, Martin, good morning, bud. Good to see you. We're also going to talk about some similarities between Clint's law firm with his dad in Tuscaloosa and our law firm here in Birmingham with big family-run businesses. So thank you guys for spending a couple of minutes with us. Clint, if you would, just tell us a little bit about yourself and your firm.
Sure. As Bernard said, my name is Clint Mountain, and I'm an attorney in Tuscaloosa, Alabama. I've been practicing for 15 years with the law firm of Mountain & Mountain. As Bernard said, it's my father and myself, and my father has trained me under his own school of lawyering, and he's been practicing 50 years this past April. So he's been doing it a long time and is still going strong. My wife and I just had a baby girl on my 40th birthday in May, and she turned 3 months this past Sunday. So if I look tired, it's because we've got a new addition to the family. It used to be just the cats and the dog keeping us up, and now we've got another little girl that's keeping us on our toes.
That's awesome. That's fantastic. I know those feelings are ones that'll stay with you, but those days go by so fast, and all of a sudden they're 22 and out of college and doing their own thing. So enjoy the time, Clint. The Mountain & Mountain firm in Tuscaloosa, as Clint said, has been there for 50 plus years. His dad has been a very successful, very well known attorney, and Clint's had the privilege of practicing with his dad, which I'm sure has its ups and downs, and we'll get into that in just a few minutes. But one of the areas that Clint practices that we wanted to bring him on to talk about today is an area that very few lawyers, very few, and even less people really know about how this works. And hey, Jordan, good to see you, bud. And it's an area about what happens if you feel you've got to bring or need to bring a case against either the state, a city, a municipality, a county, some level of government. And I'm going to let Clint kind of get us into that a little bit to show us what those laws entail a little bit. And then we'll give some real examples and show you how all that ties in together. So Clint, why don't you kick us off a little bit and talk to us a little bit about that?
Sure. As I said, our firm is a small firm, and being a smaller firm, we handle a lot of different types of cases. I can tell you that I've handled everything from medical malpractice and food poisoning to your run-of-the-mill car wrecks and trucking wrecks and things of that nature. And I think this area of the law has really come up because of where we are, being in Tuscaloosa. We're right there with the university, and so we get a lot of calls about people who are upset with the university. We have so many healthcare facilities there in Tuscaloosa as well that are run by the state, and sometimes there are instances that happen there. And that's kind of where I remember starting with this type of law. And the calls that we get are something has happened to me either by a city employee or at the hands of the city, the county, the state, and what do we do? And as Bernard alluded to, it's a completely different creature than what you're used to handling as an attorney, where you'd have a defendant who's a private defendant who's not afforded the same sort of protections that someone is afforded if they're a governmental entity. And we're talking about the city, the county, and the state in particular. For instance, let's suppose you were hit by a garbage truck. So you're rear-ended by a garbage truck rather than rear-ended by your neighbor. Well, if your neighbor hits you, it's pretty simple. You file on their insurance and pursue a claim that way. If you're rear-ended by a garbage truck, well, at that point, you have to make a claim with the city. One of the requirements in particular as it relates to municipalities is you have to make a claim, or you have to exhaust your administrative remedies making a claim. And what that means is you have to either fill out a form or write a detailed letter stating what happened and present that letter to the city so they have an opportunity to review it and try and resolve that claim before you file suit.
And when you do that, when you're putting the city on notice of what happened to you and your involvement, how you got hurt or how you were damaged by the city, do you necessarily need a lawyer for that, or should you consult a lawyer for that?
You don't necessarily need an attorney to do so. However, I would recommend speaking to one. Even if you don't hire an attorney, just have an attorney that can give you some guidance to do so, because those notices of claim have particular requirements. And if you don't meet the requirements and your notice is inadequate, well, then you have you've committed an error in the very beginning that will prevent you from any litigation going forward.
You might have missed your opportunity to then go to the next step if the city or the municipality denies the claim.
Exactly.
And there are deadlines to file these notices, these claims. So maybe you do really need to consult with an attorney who handles these matters. And certainly if you're in Tuscaloosa or anywhere nearby, Clint's the guy to go to. Clint, let's say that in your scenario, we filed our notice with the city, and the city has investigated it and comes back and says, we don't see it your way. We're denying that we're responsible for any of this. What happens after that?
Well, at that point, if the city, what happens after you file a claim is one of two things. Either they will acknowledge your claim and they'll give you a response to say, yes, we're responsible, no, we're not responsible, or they'll ignore it. If they say, no, we're not liable, or they ignore it for the requisite time period, then at that point you have the ability to file suit against the city and its employees. You can sue them in their individual and official capacity.
Sure. And it's, I guess every case is fact specific. So maybe that's, again, another reason why you need to call somebody like Clint. But for those of you just joining us, hey, Brennan, Joseph, Charles, and Shane, thanks for joining us for a few minutes. Talking with Tuscaloosa attorney Clint Mountain Law Firm. Clint is talking to us about lawsuits or claims that you may have, whether it's for injuries or damages against municipalities, which could be a city or a county or even the state in certain circumstances. Clint, and if you guys have questions, whether you're watching us live or later on, just put it in the comments section. We'll make sure that Clint gets the question, try to answer it or address it. Clint, let's talk about the next step. Let's say that the city or the county, they've denied your claim. That didn't happen the way that you see it. They see it a different way. And then what's your next step? What do you have to do?
Your next step is to file a lawsuit against the city, and also recommend not only filing the city, if it's a city-owned dump truck, city-owned garbage truck, you also need to file suit against the individual who was driving that truck, and that's very, very important. If you look at the law governing suing municipalities in Alabama, there is a $100,000 cap on any of your damages that you can recover against the city. So if you lose a limb, if someone dies, no matter what the circumstances are, there is a $100,000 cap, $300,000 per incident. Now, when they defined what the municipalities were and what the scope was back in, I think it was 1975, 1977, they were very specific when they defined what a governmental municipal entity is. They did not, however, include employees in that definition. So if you have got the city sued as well as the employee, there is no cap on the employee. So it's very, very important when you're crafting your lawsuit to look at those types of defendants and make sure you add everyone that you can.
Clint, I know that there are also a lot of times the municipality or whoever's responding will use certain defenses as the reason why they may not feel they're responsible. And one of the biggest ones is being put on notice. So let's talk a little bit about some of those defenses.
Well, some of the notices, and typically for the city and the county, the notice requirements are one that you have to, as we were talking about earlier, the notice requirement is that you file your notices prior to filing suit. They have to have notice of your claim before filing suit. Then, if we're looking at the other notices requirements, we're talking in the context of, say, a stop sign that's not there, or a sidewalk is not typically what they knew or should have known, but were they on actual notice? If you have a premises liability case in somewhere where you have a slip and fall, so they're commonly referred to at a Walmart, somewhere like that, sometimes you can find where they have breached their duties where they're supposed to be looking at things but didn't do it.
Sure.
Somebody should have gone through that area and somebody should have looked for spills and they didn't do it. That's not the same with the city. The city has got to have actual notice that there was a problem. So if you tripped on an area in City Hall or you tripped on an area on a sidewalk, just the fact that there was a problem there is not enough. There has to be actual notice in the city, a written complaint, a phone call, some sort of notice that they knew that there was a hazardous condition and failed to remedy that condition.
Like on this sidewalk example, let's say you're in downtown Tuscaloosa and you're going to one of the shops on the street and the sidewalks are run and owned and operated by the city, and there's a big hole there and you didn't see the hole and you break your leg as a result. If the city had not been previously told about that hole and given an opportunity to at least put up barriers or to repair it, is that the kind of notice that you're referring to?
Yes, and so the city would, if the hole had been caused, let's say by a tree, the tree branches had grown up and caused a condition, the city may not know about that. Now, if a city worker had been out there earlier and dug that hole and left and didn't put those barriers up, well, the city is on notice because he actively created that hole.
I see. I've got one case that I handled probably 10 years ago now, where a school teacher in one of the small towns up North Alabama actually hit a big divot in the road in this downtown area. It was still residential, but it was still considered downtown. And when she hit that divot, she lost control of her car and went down into a cement culvert. And as a result of that, it was a very bad injuries for her, numerous surgeries. She missed work for a year and a half. Well, we did some research and we found that a truck about 10 days before had gone through that street, which big trucks were not supposed to. And when it tried to turn around or make a maneuver, the back of the truck dug this divot or this big gash in the cement, or not cement, the asphalt. And the city knew about it because somebody had complained who lived on the street. Long story short, they never did anything about it. 10 days later, my lady, comes through and has this horrible crash. Well, the city ended up taking responsibility for that because they had it on record that somebody had complained to them.
And that's exactly what you're talking about is the notice requirement. There you have a third party that created the hazard. However, the city was on notice. So now the difference would have been if the garbage truck had done that and they turned out, well, it wouldn't have needed the notice requirement because the city actually created the hazard. But in this case, you've got a third party. And somebody's called, somebody sent that letter, somebody said, hey, y'all need to come fix this street. Somebody's going to get hurt. The city's on notice and they're supposed to take care of that.
Yeah. For those of you just joining us, I've got buddy Clint Mountain, who's Tuscaloosa attorney. We're talking about claims, not necessarily lawsuits per se, but they can lead to lawsuits, but claims for damages or claims for injuries against municipalities being either cities or counties or governmental agencies. Wanted to say hey to Bruce and to Bridget for tuning in for just a minute or two. And if you guys have questions, please put them in the comment section. And when we finish, I'm going to put all of Clint's law firm's contact information. So if you've got questions you want to talk to him offline, we'll be able to get you in touch with him. Clint, let's talk about, and we'll wrap this up in just a second. Are these, if this case, if these scenarios, if the claim's been denied, you've had to file your lawsuit, are these cases that are tried, are they tried in front of a judge only, or are they tried in front of a jury? Talk to us a little bit about that.
Municipalities, you're allowed to have a jury. Municipalities and counties are allowed to have a jury. It's the same as the state. Any cases against the state, any cases against the county, municipality, they're all allowed to be a jury trial. Now, there are scenarios that you see in the federal government, which would be operating under the Federal Tort Claims Act, in which case they have a lot of different rules. They have some of the notice requirements, but one of those rules is that you are not allowed to have a jury. Everything is done by a federal judge. It's what we call a bench trial, and where you only have a judge who determines both the facts and the law in the case. That's also true for many Native American tribes within Mississippi and Alabama. They also have patterned their rules after the Federal Tort Claims Act, where you're not allowed to have a jury.
Very good. Well, guys, if you have any questions, concerns, or know of anybody, or if you've been involved in this type of a scenario, this is your guy to go to. Clint knows his stuff, and he's a great lawyer. He and his dad run a very, very reputable and very good firm in Tuscaloosa. But his cases aren't limited to Tuscaloosa. He's around out and about around the state. But that's going to lead us. I want to pivot for just a minute, and here's where we may get in trouble. I want to talk about, we've got a lot of similarities between our firm, the NOMBERG Law Firm, Mountain Law Firm. Both of our dads are part of our firms, and you've been practicing for a number of years with your dad. You've known him most of your life, or not kidding. And our dad is happily retired down on the Gulf, but he stays active with us. We consult with him from time to time. And knowing that your dad is going to be watching this at some point in time, let's talk about that. Let's talk about what's it like going to practice with your dad.
I guess at this point, I may be getting myself into trouble. No, and matter of fact, your father Joel's good friends with my father. Graduated about the same time.
They were in law school about the same time.
I know they're Facebook friends because I see them going back and forth all the time, talking to one another. But it has been a great experience working for my father. My parents were divorced when I was younger. I grew up in Montgomery. My father stayed in Tuscaloosa, and I have 2 sisters and a brother, and I'm the only one of us who practices law, and certainly the only one who practices my father. And I do have a very special relationship, having done that work with my father. I don't think there's anything that would make me want to change that. He is, having practiced as long as he is what we would call an old school lawyer, and a lot of what they do is a lot of trial by fire. And I can remember being sworn in to the bar on a Wednesday and helping him strike a jury that next Monday.
Oh, that's awesome.
There was not a lot of lag time, a lot of celebration time, and I have a feeling had that jury trial started on the Thursday, I'd have been right there front and center helping him strike a jury.
I know those are special memories. Our dad practiced down in Dothan his whole career, and then moved to Gulf Shores. David and I ended up settling in Birmingham, so we never had that privilege of trying a case or practicing actively with our dad. So I know you hold that dear. I know one of the things, and this is certainly not to make fun of your dad or my dad, but it's a generational thing when it comes to social media, when it comes to client communications and things. And we probably hear the very same stories you do. Well, back in my day, this is how we do it. But I assume that your dad has also adapted with all the modern technology and the way that you do things at your practice. You know, we don't have copier machines. We don't have big libraries anymore. So that's, I'm sure, has been equal parts interesting and fun, and maybe a little frustrating for both of y'all to move your practice forward.
It is, and having the social media presence. My father's very, very active on social media, and sometimes I have to tell him, let's some of the topics that we're talking about need to make sure that whatever you're doing is just like standing outside or meeting somebody at a restaurant. How you're presenting yourself and how is going to be perceived as you're representing the firm. And I'm not saying my father's done anything bad, but let's say he posted something about how much he loves Alabama or Auburn or whatever it may be, making people, potential jurors, that may not like that. You have to be aware of that.
That's true. It's true. It's very easy to get caught up in whatever the social chatter is at the time, but you always have to be mindful about who's out there watching. Just like we've got a few folks here watching now, but no telling who's going to be watching it after we finish here today. But for you guys who've just joined us and those who've stuck with us, we really appreciate it. Hey, Kay, hope you're doing well. And Gary, thank you for Judge for tuning in for just a minute or two. I've got my buddy Clint Mountain from Mountain Law Firm in Tuscaloosa. We've been talking about sovereign immunity. We've been talking about municipal liability, and Clint really knows his stuff here. We've also been talking about family-run law practice and multi-generation law practices, and that can be fun. It can be challenging, but it can also be very rewarding. Clint, in closing, and I appreciate you giving us your time, do you have any predictions on the Tua versus Jalen decision that will come out later today?
Gosh, that wasn't ready for that question. That's a tough one. I honestly think Jalen will start. I think he's deserved the opportunity to start based on his record, and that may not be a popular opinion. I think that Jalen is a winner. I think the kid works hard. I think that he just needs to develop some of his skill set. And I think he'll start, and whether or not he'll keep that job, I don't know.
You heard it here first, right here, expert opinion. Guys, thank you for spending some time with us today. This will conclude our NOMBERG Law Live for this week. As always, we come to you every Tuesday at 10 o'clock Central, 8 a.m. Pacific. After you're watching this, when it's no longer live, you're certainly welcome to put your comments into the section there. We can make sure that Clint or his firm, his dad, somebody gets those questions and answers them for you. hope you guys have a great rest of your week. Clint, again, thank you for your time this morning.
Thank you for having me. I appreciate it.
Absolutely. Absolutely. Guys, hope you have a great, safe Labor Day weekend. Hope you're doing something fun. I know the college football season kicks off in about 48 hours in earnest. So you guys have a great rest of your week. We'll catch you next week.